Commission, August 14th, 2019. Commissioner Borges, will you please lead the flag salute?
All rise. Ready, begin. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Madam Secretary, will you please call roll?
Thank you. Commissioner Edwin Borges.
Here.
Commissioner Edith Flores.
Present.
Commissioner Christopher Sines.
Present.
And with the vacancy of the chair and the vice chair, Commissioner Sines will serve and conduct this meeting.
Actually, we need to take a quick vote on Chair Pro Tem, since we have another meeting without a chair. So, would be able to nominate? Yes, go ahead and nominate.
I would like to nominate Commissioner Christopher Sines for chairman.
I second that.
All in favor?
All in favor?
Aye.
Aye.
Okay.
Motion passes.
Motion passes.
I now declare oral communications open. Anyone wishing to address the Commission on anything other than the items listed on the agenda may speak at this time. Please give us your name and address and restrict your comments to 3 minutes. See no interest. I close oral communications. So moving on to the consent calendar. Consent calendar, item number 1, action minutes from July 24th, 2019. Commissioners, do we have a motion to approve?
A motion to approve.
I second.
All those in favor?
Aye.
Motion passes. Consent calendar, item 2, action minutes from June 12th, 2019. Seeing as there isn't sufficient commissioners here to approve the action minutes.
Then I would recommend that the Secretary of the Planning Commission draft a letter certifying that the minutes are true and correct, and that way the commissioners who are not there can vote on it based upon that certification. That would be at the next Planning Commission meeting. So
a motion to move the approval of action minutes from June 12, 2019 to the next Planning Commission meeting with the letter of letter of certification from the Secretary of Planning Commission that the minutes are true and accurate.
A second.
All those in favor?
Aye.
Aye.
passes 3-0.
We're moving on to set matters public hearing to consider the appeal of an order of abatement of non-conforming use submitted on behalf of Dalewood Holding LLC, owner of the real property commonly known as 14624 Dalewood Street, Baldwin Park, and identified by assessor parcel number 8463-001-014. Mr. Ron Garcia.
Thank you, Commissioner Sines. Staff Counsel Jim Eckert will be providing the presentation on this matter.
Just for the Planning Commissioner's edification, Mr. Eckhart is an expert in land use and nonconforming abatement orders that we have before us today. He was hired as special counsel to assist staff in putting together a staff report and the attachments and the draft staff resolution. Mr. Eckhart?
Thank you. So the Planning Commission should have already received the staff report, and included with that staff report is various attachments, one of which, attachment 7A, is a legal analysis providing the Planning Commission with the authorization to actually, that the staff is relying on for purpose of doing the termination of the non-conforming use at this subject property. It would be the same authority that the Planning Commission would be relying on. We are going to provide a little bit of a presentation, but I'm not going to go through everything that was spelled out in the staff report. We did a very detailed staff report for the Planning Commission's edification and make it easier, but there are certain things that we do want to go through and just kind of give a brief rundown of what's being presented here before the Planning Commission. So the first thing is just to understand that while zoning codes are typically drafted in an effect to be prospective and to design how the city is going to be developed throughout time. A natural component of any zoning code is we end up with non-conforming uses. We end up with uses that were legal at the time under the codes that existed, but codes then changed and they become non-conforming. And so a goal of any zoning code is ultimately to terminate and abate those non-conforming uses, because we want everything to start to comply with whatever our current laws are, our current development plan is. Specifically, the one that we're dealing with is under Baldwin Park Zoning Code, section 153.200.060, subsection E, which requires non-conforming uses to be terminated and abated within 20 years of the date that they became non-conforming. There are other abatement periods for different types of structures, for different types of uses, but the one that specifically applies here is the general 20-year period of time. It's undisputed that the property that we're talking about, 14624 Dalewood Street, commenced as a motel use back in 1967. And as a matter of fact, the certificate of occupancy was actually issued in 1967. The permits were pulled all throughout 67, culminating in the business getting its certificate of occupancy in December. And that's undisputed. So there's neither side, either staff nor the appellants here, are denying the fact that this business existed back in 1967 and existed as a matter of right at the time. No conditional use permit or anything else was required at the time other than the typical business license and the various development permits that they obtained. The use, however, became non-conforming in June of '81. In May of '81, the City Council adopted Ordinance 818. It became effective in June of '81, and at that time, the change that happened was that a motel use at this property in the zone that it was, which was a C2 at the time, required a conditional use permit. So obviously, because this particular business started prior to the conditional use permit being required, it became non-conforming as of June of '81 when the law now required conditional use permits. So under our code, they have a 20-year period of time to abate that non-conforming use. So the use of this property should have been terminated in June of 2001 under that 20-year statute. The city ended up issuing an order of abatement in March of 2018 to the current property owner who purchased the property in, I believe it was December of 2014 or January of 2015. They issued the notice of abatement or the abatement order in March of 2018, and the appellants went through a process and they timely appealed this, which is why we're here before the Planning Commission today. This is a hearing de novo, and so this is not per se a approval of the order of abatement. Rather, you are reweighing everything, and we're going to go through part of this just to kind of describe to you what your obligations are as a Planning Commission. The sole issue before the Planning Commission tonight is to determine whether the 20-year period of abatement that is set forth in the zoning code is an appropriate and reasonable time period as applied to the facts of this specific case. So understand that the abatement periods that are spelled out in the code, by definition, are a prima facie period of time. And it's up to the Planning Commission to weigh the facts of this particular case to determine whether or not the 20 years was an appropriate period of time. And the zoning code specifically spells out the exact obligations that the Planning Commission, and if it gets appealed to City Council, would have to analyze to determine whether or not the 20 years is reasonable. And it's four things. One, the date the building or structures were constructed. That's one thing we're going to have to consider tonight. Two, the original costs of construction. Three, whether the original cost of construction has been or could have been recovered by the owner at the time. That is, when we terminate a non-conforming use, we want the owner of the property to be able to somehow recoup the investment that they did, because they're potentially going to lose the ability to do that use in the future. And four, whether the building or structure can be relocated. Okay, so these are the four things that we're going to go through. So we're just going to look at these four things. Number one, the date of construction. As I indicated, the permits were all pulled in 1967, culminating in a certificate of occupancy being issued in December of 1967. So that's our date of construction. This building, and the use has been ongoing since 1967. The original cost of construction. Now, we don't have the actual cost of construction. What we do have is the valuation that was put on the various permits that were used in order to construct this building. And the valuation of the various permits that were pulled was $513,669. Okay? So that was the valuation that the applicant at the time, the property owner, put down on the permits in order to pull the permits as to what the value of the construction was at the time. The actual cost of construction might have been much less, but that was what the valuation was for purpose of determining the cost of the permit. 3, the amortization of the original cost. Could the owner, or did the owner actually, was the owner able to recover the original cost of construction? So remember, this is a motel that had been in use since December of 1967, went through, became nonconforming in June of 1981, got an additional 20 years after that to 2001, and actually continued operating all the way up through February of 2017 when there was a fire at the building. So it was able to operate from 1967 all the way up to 2017. And the question is, could they have recovered the cost, $553,000 of the valuation, within that period of time? Were they able to recoup their investment in it? And it's important to look at that what the Planning Commission is looking at is not just the 20 years that's set out in the code. It's the actual time that has been granted. Okay? Because again, the Planning Commission is obligated to look at the specific facts of this case. So in actuality, even though the non-conforming use should have terminated in June of 2001, it continued through February of 2017, and the city did not issue an order of abatement until March of 2018. So they got approximately 38 years as a non-conforming use. And that's part of what the Planning Commission is looking at, not just the 20 years, but the full 38 years that they actually were able to obtain. And again, the question is, could they have recouped the investment, the original cost of construction, during that 38-year period of time? And remember, it's 38 years since it became non-conforming. There was actually from 1967 to 1981, right, where it was a legal business, a conforming business prior to the CUP, but they were recouping the cost of investment all the way back from 1967. So they've had more than 38 years, because it was from basically 67 all the way up to present day. Okay? And so it seems clear that they've been able to recoup the investment that was originally put in this by having been an operating hotel from 67 all the way through February of 2017. And it's not required for the Planning Commission to consider it. That is, what the Planning Commission is required to do is look at the original cost of construction. But we went further than that, and it's kind of outlaid a little bit more in the staff report, and there's even a spreadsheet that is attached to the staff report as Exhibit 6, or Attachment 6, that spells out the permits that have actually been obtained since the property became non-conforming. So we know that the valuation of the original construction was the amount that was indicated earlier, which was $513,669. So that was the original cost. Subsequent to that, and it's broken down in the staff report in more detail, but basically they obtained permits, the prior owner, prior to the current owner, obtained permits, an approximate aggregate amount of $47,000 worth of permits. And again, this is valuation of the work that was done. And for the most part, as indicated in the staff report, it was relatively minor work that was being done. So one of the things that was done, of that $47,000, $20,000 was for a big pylon sign that is still existing at the location. And by the way, is something that can continue to be used at the location. So the value of that is not necessarily going to go away. But $20,000 of that $47,000 came from the construction of a pylon sign, which they had the use of in order to advertise the business. About another $12,000 was for re-roofing, various re-roofing permits that they did over that period of time. So of that, that's already $32,000. That was really only for a sign and some re-roofing. What I'm saying is there was actually very little investment that was done back into this property. And so even though the Planning Commission is not required to look at subsequent valuation, subsequent investment in the property, We're putting that forth because we believe that is a fact that can be considered by the Planning Commission. It's not required to be, but can be. The current property owner, since the current property owner obtained the property, has pulled one permit. That one permit was to install 72 sliding glass doors and a window in the lobby with a valuation of $10,000. That's all the current owner has actually invested back into the property to date, other than the plan review process that was commenced in order to remediate the fire damage that occurred in 2017. So again, we've got a total of about $57,000 that has been expended in investment purposes going back as far as permits have been issued by the city from 1968, let's say January of 1968, after the building first opened, to the present day, only $57,000. That is above and beyond the initial $513,000. The code requires you to consider the relocation of the structure. And again, the reason behind that is to determine, well, is there some ongoing value? Will they still have a value to what's there? So even if we terminate the use, could they relocate the building somewhere else? The benefit that the appellant has in this case is there's no need to relocate the building because a motel is a conditionally permitted use at this property. So they're not losing the entire value of what's been invested back into this property, either the original construction or even the subsequent investments that they've done. They're not losing that because the building, the sign, everything else that's there, if it wasn't damaged by the fire, is something that can still be utilized. It would just be subject to a CUP. It would require them to come in and get a CUP, and all of these things would still be viable structures that they could use. Because of that, relocation is not really an important factor. Because again, there's no need to relocate it in order to get a use out of the structure. They can keep it at the same location and still get a use out of the structure. Mitigating circumstances. Now, in addition to the staff report that was prepared by staff, there were various documents that were submitted by the appellant. These documents discussed not only legal arguments as to why the process or procedure has been flawed, but also their efforts to try and rehab the building after the fire, their efforts of dealing with the insurance agency that they had, the adjuster. There's really nothing in that mitigates the issue that we're here for today. The sole issue that we're here for today is to determine, is the 20 years, or again the total of 38 that they've actually been granted between all the owners, a reasonable amount of time to terminate a non-conforming use. Whether or not they diligently pursued a permit to rehab this structure in 2017 or 2018 after the fire is not really relevant to the discussion that is before the Planning Commission today. Even if I believed that they were diligent, and I don't, but even if I did believe that they were diligent, it doesn't impact the fact that 20 years had come and gone as early as 2001. And here we are now in 2017, and then 2018, and now 2019, and the non-conforming use has gone on. They've had that ability. And the question is, was that a reasonable amount of time? The termination that is before you is different than in other cases that might come before the Planning Commission, where the termination is the result of bad acts by the property owner or by a business operator. It's not. This is before you purely because of a question of time. The code authorizes the termination after 20 years. They were granted 38. Is that reasonable? Is that a reasonable amount of time for them to be able to recoup their investment, but still allow the city to achieve its goal of terminating non-conforming uses so that properties are developed and used in accordance with our currently existing laws and our current development plan? That's it. Everything else that's going to be talked about is really not relevant to today's proceedings. As evidenced by the legal authorities that were provided as part of the staff report, termination of non-conforming uses is allowed. Cities are authorized to do this. It is different than a forfeiture. It's different than a confiscation. It is not a taking in the same way as a forfeiture or confiscation is. We're not taking the property away. We're terminating a use. Property still remains in the property owner's hands. The property owner still has the right to use this property, whether it's for a motel with a CUP or for any other use that's allowed at the property. And because of that, the courts have indicated that what we look at then is the reasonableness of time that has been provided. Again, the city didn't say you have to terminate within 1 year, didn't say you have to terminate immediately. It said 20 years. And between all the property owners of this property, they got 38. So almost double what the city council originally approved when that 20-year abatement period was actually adopted back as far back as 81. Okay? So that's what we're here to do. And really, there's no mitigating circumstances that has been submitted so far. Now, obviously, appellant's counsel will come up and talk, and it's possible appellant will as well. But nothing has been submitted to date that really mitigates or gives the Planning Commission a reason to do anything different than uphold the law that the City Council adopted with a 20-year provision and determine that that was a reasonable amount of time. And again, specific to this case, the specific facts of this case, that the 38 years is a reasonable amount of time to allow somebody to terminate what is otherwise now a non-conforming use. So because of all of that, staff is obviously recommending that the Planning Commission determine that the 20-year abatement period, and again, the 38 years that has been granted to the appellant or the prior property owners, is reasonable and appropriate given the circumstances of this case, that the Planning Commission deny the appeal, and that the Planning Commission adopt Resolution 19-16, terminating the non-conforming motel use at the property. And obviously, I'm available for any questions that the Planning Commission may have.
Are there any questions of staff by the commission?
I have one question. When did the new property owners come into play?
I believe it was in December of 2014, but if I can get just one moment. Yeah, I believe it was December 30th of 2014 is when they actually acquired title. I believe the deed was filed in January of 2015, but I believe the sale was actually December 30th of 2014.
Thank you.
So I have a question. So I understand that we're trying to look at kind of like through the lens of what you had spoken about. And of course, I believe that 20 years typically be sufficient. But considering that the ownership of the property changed, does the law stipulate that we are required to look at it through a different lens, or are we solely looking at it, the ownership? So I would imagine that in 20 years, the original owner could have recouped costs, but it's hard to believe that an owner in 4 years would have recouped costs. So I guess my thought is the law only requires us to look at the lens of the original ownership in the period of the.
Correct. So the law requires you to look at it from purposes of, again, the initial investment in the property. And at the time that the property became non-conforming, could that owner have recouped the costs of the investment that they put into the property? Okay. Now, what's interesting about looking at the dates is this property owner actually, again, purchased the property in December of 2014. Okay? 13 years after this property had already had, in essence, passed its 20-year period of time. So in doing due diligence and purchasing a property, this is something that one would uncover if they did their due diligence to look at what are potential uses at that property. And then they would have been able to discover that, hey, I'm already past my abatement period. I mean, we're running on fumes at this point. You decide to invest in that property, that's on you. Right. And the reason why the law requires you to look at the original owner is because, again, the original owner is the one who started something while it was legal. And it became non-conforming because the city decided to change the zone or the zoning regulations. And so that person is the person who is suffering a potential loss. Anybody who acquires it after that is acquiring it with full knowledge, or at least should have had full knowledge, about what the ramifications of purchasing that property are. And so we're not required to look at it through the lens of the new owner, other than the fact that, again, technically, the new owner bought it 13 years after it should have already been terminated.
Right. Perfect. I appreciate it. Thank you. No further questions. I'm going to open the public testimony. If there's anybody in the audience wishing to testify on this matter, either for or against, please state your name and address, and please limit your time to 3 minutes.
Actually, we can we'll let more time.
Actually, it's going to be open-ended. Feel free.
On behalf of the present owners, Harold Greenberg, 2263 South Harvard Boulevard, Los Angeles, California. There were 2 other attorneys with me, Frank Weiser and Mitch Ducey. They would also ask permission to speak to this particular body, and I appreciate the fact that we do have this opportunity. What we're looking at, frankly, is a question of justice and fairness. Our client purchased this property in December of 2014. The city did not contact them in any way indicating that there had been a problem as far as the non-conforming use, an abatement, or frankly, an ordinance. My client had a business that was running. It did not create any problems for this particular city. There's no showing that there were any type of violations, police or otherwise. They invested millions of dollars to purchase the property. They relied on title reports, etc., and nobody came up with the ordinance. In addition to that, the city accepted various taxes from my particular client, including various licenses, etc., that they had been in business, they were still in business, they were never told that this was something that would be abated. It's a question of justice, it's a question of fairness. When there was a fire, and the fire happened in February of 2017, the first time the city did anything would have been somewhere around August of 2018. When we're taking a look at the particular situation, my client was working with and trying to have the assistance of an insurance company. My client, just as a result of the fire, has put in over $1.3 million to do the various work that has to be done. What we can do at this particular time, and with the indulgence, frankly, of this panel, is if we could put this over for another 3-4 months so we can go through the process. As I have discussed with Mr. Eckert, we can come up with 100 units. There are 72 now. My client has been in contact with Holiday Inn. They are working on this with my client. So it's not a question of trying to take anything away from the city, causing any problems to the city. It's a win-win position for both. We have a situation, frankly, where this can not only help my clients, but can help the city. Because, as council has said, for the city, they don't have to relocate the property. But that makes no sense. Obviously, if they cannot remodel and rebuild and expand, they have a property that is useless and it could be a hazard. When we're talking about the property, we have been in contact with the contractor, the architects, etc. This can be done. What we need is sufficient time to do it. It is obvious that if the city knew that there was an ordinance in 81 which would expire in 2001, somebody should have been notified. That wasn't done. My client utilized the title company, utilized real estate brokers, etc. Nothing came up. It's a question of actual notice. It could be a question of constructive notice. When we're looking at this particular situation, there's been no harm to the city. The harm, frankly, has occurred to my client because for over 2 years, she has not received any income on this particular property. Part of the problem, the appeal was filed in August of last year. We were not notified until 2 months ago that there would be a hearing now. We put in the papers at the appropriate time with the appropriate reasons that we wanted to go forward. We wanted to do something that my clients would be proud and what the city would be proud of. So the issue is, do we have sufficient time, another 3 to 4 months, so we can do what has to be done? When we're talking about this particular situation here, there is not a situation where there has been harm to the city other than the tax situation, and that has frankly harmed my client. What we're asking for is frankly discretion that this body has. When we're talking about it, we can do it. We've made the contacts. We've been working on it. I have not only met with Mr. Eckert, we have spoken several times on the telephone. We are working on it, we are doing it, and we will get it done. We need the opportunity to do it. Now, I'd like to call on Mr. Weiser.
Thank you, Mr. Greenberg. Frank Weiser, I'm co-counsel with Mr. Greenberg and with Mr. Ducey. We do have pending litigation in federal court, and Mr. Greenberg and I are co-counsel on that case. But I do want to point out one thing. I think Mr. Greenberg made an excellent presentation here of the underlying facts and equities that I think, compel this commission to really consider seriously as far as putting it over to allow the CUP process. But I do, I have a great deal of respect for Mr. Eckert and his firm. I've had work with them. We even have a published case in the Ninth Circuit several years back with Bill Litvak, his partner. So I know Mr. Eckert, I know Mr. Litvak, and I have like I said, a lot of respect. But I do take issue, respectfully, with the way the characterization of the law in the area. Taking the City of Baldwin Park's code and taking it at its face value, that doesn't mean that the code can somehow abrogate constitutional or statutory principles. And in particular, I'm going to concentrate on federal law here, and because we are in a federal court. I'm not going to belabor the commission with everything I stated in my original appeal letter, but there is one point on the takings issue. The takings issue is a lot more complex than simply looking at the original cost of construction in the 20-year amortization period. There's federal background principles that apply here. And in particular, there's a case called Penn Central versus City of New York. I believe it's a 1988 U.S. Supreme Court case. And what the U.S. Supreme Court has said in regulatory takings, we're not talking about a physical taking where a city appropriates property for eminent domain, or a case where the city somehow physically occupies a property, but where a regulation is deemed to perhaps go too far, and even if it is legal and constitutional in being legal in itself, it can still affect a taking under the Fifth Amendment for purposes of the Just Compensation Clause. And that's what I think the Commission should concentrate on here. The Supreme Court said in the Penn Central case it's an ad hoc factual inquiry. In other words, a court or a commission would balance equities. And one of the equities would be the reasonable expected investment-backed expectations of the owner versus the character of the regulation. And then there are some other factors involved, but those are the two principal factors. Now here, I think Mr. Greenberg really hit the nail here, exactly what we're talking about. We're not talking about original construction. We're talking about an owner that came in subsequently after what Mr. Eckert is saying was already a legal nonconforming use that had terminated in the 20 years, bought a property, obtained business licenses from the city continuously, and I think that's without dispute. I think we issued or gave Mr. Eckert, and it's part of the administrative record now, the last license that the owner had prior to the closure, and pay taxes. And the city was aware of that. And the city accepted taxes. And if the city says that you were no longer even a legal nonconforming use and you somehow terminated, they should have done that at the initial beginning of the process. So I think the reasonable investment-backed expectations of the owner in this case, the new owner, is as the commissioner asked, from the date of 2014, December 2014. Even given your code does not reflect or take into consideration the Penn Central test. Now, given that, I think the practical aspects here are what should be the dynamics of this case right now. Because if the owner is going to come before the commission and actually ask for a CUP, then I think Mr. Eckert will agree that if she is granted a CUP, all these legal issues go away. The complexity of the takings issue, the due process issue. Mr. Greenberg pointed out that there was close to a year's delay before Mr. Eckert got into the process. And it's very, very clear that regardless of whatever the underlying takings issue is, my client had a right to a prompt post-deprivation hearing, if not a pre-deprivation hearing. So from the time of that order of abatement, she filed a timely appeal. She should have gotten an appeal before this commission a long, long time ago. There's a lot of money that's been lost as a result of that. Another point as far as the taking. The taking is not simply the use of the property, although I think that is the central issue. But the taking is also her reasonable investment-backed expectations from the point of when the fire occurred. The city gave her a conditional permit, as I understand. It was over $1 million. I think Mr. Ducey can tell us more about that, of how much money was spent to fix it up with the expectation that she would be able to complete the work and then reopen. Now, I was told by the owner that, in fact, the reason why that 1-year period could not be met was that while they were working on it, they had already completed the work within the 1-year period, but the staff did not sign off on it. And because they did not sign off, it couldn't be completed within the 1 year. So there are two distinct issues here. It's very complex as far as what constitutes the taking. First is the use issue from the date of the ownership. The second is what the money that was spent from the point of the fire. Finally, I would like to point out that I don't agree with Mr. Eckert. I respectfully disagree. I don't think the standard here is the Penn Central test, but I don't think the standard here is that the termination of the legal nonconforming use is not a taking. I think it's very, very clear, both state law and federal law talks, that if an owner puts an investment into property, there's a case that I think I cited in my appeal papers, and it's a case called Goat Hill Tavern versus City of Costa Mesa. And although that was a termination of a conditional use permit, but nevertheless a major, major factor that the Court of Appeals in the 4th District Division 3 determined was the investment of the owner in their business. And that had to be considered in weighing the equities of the case. Here, we have an owner who bought it in 2014, December 2014. She's invested a lot of money into this property. She's relied upon that investment. The city did nothing until after she had already gotten a permit, had done the work. I think those equities favor the balance of equities in her favor. That being said, as I said, I support Mr. Greenberg strongly that the commission should put this over for 3-4 months. Let her put a COP application, and let's see if we can practically solve the issue. Thank you.
Good evening. I appreciate the opportunity to speak. I'm Mitchell Ducey, and my address is 15260 Ventura Boulevard. I have a very different perspective on this because everything that the other attorneys are talking about are literally outside my wheelhouse. I have a client. I was called in to assist on this case in February of 2017. Jane Sun is here, and she's the member of Dalewood Holding LLC. I do have a specialty in insurance law, and I was trying to assist with the adjustment of a loss. Now, I heard what Mr. Eckert said. I can't dispute how Mr. Eckert defines this issue for this honorable commission, that is it reasonable for that period of time to have passed, whether it's 20 years or 36 years when this fire occurred. But I think that's not the issue. I think the issue here is the process by which my client has come to a point that they have reasonable. The process itself, I think, doesn't work. And here's why. We were moving along on the rebuilding of this property. Dalewood has spent over $1.3 million out of the $1.9 million that it's gotten from its insurance company. We're talking here about the amortized costs of, and calculating that and what's reasonable. But I think what has to be noticed in this case is that a mitigating factor is the loss that there's been to my client. She bought this property for over $4 million. She wasn't notified of anything wrong with it. The city slept on its rights for 16 years without notification. What in the world would happen to the city of Baldwin Park if there was a major earthquake? What's lurking beneath the surface in terms of, gee, we didn't get a conditional use permit, and now we're discovering all these problems with our businesses and our homes. If you take a straight legal look at that, it's going to be a disaster for the city. In our case, my client not only paid over $4 million, she's now paid over $1.9 million to, it's been asbestos abatement. She's been fighting with her insurance company, but a fair fight. They've done everything they need to do. But the insurance company's out that money, my client's out that money, and the process where I believe it was unfair is we got to a certain point when Icon, who was the contractor, got the permits, got the plans, paid for them. City took the money. Deborah Warburn, who's the architect, submitted the plans, and the city planner at that time, I believe it was, sat on that for weeks, and we'll get back to you, until March 28th, when all of a sudden Dalewood gets this order of abatement. And we understood immediately what the law was that we're here to talk about. We counted the years. We saw all that. But for the first year, we knew it was a complex project, and we're struggling with the insurance company and the challenging rebuilding issues. And for the last year, it's simply been on hold. The insurance company keeps adjusting the loss as it should. It's meeting its obligations. Our client is doing whatever it can to adjust the loss correctly. But since March 2018, they haven't been able to do anything with this property. It sits there, a shell that could have been finished had the process gone forward according to the estimate of the contractor by July of 2018. So those are some of the other factors, and I understand. I totally get it from a straight legal standpoint. If we're counting years by reference to this statute, of course it's a long time. But if you look at the general impact of how Mr. Eckert wants this interpreted, in a case where, unfortunately, and through no fault of my client, there was a fire on the property, then just think about the ramifications for other properties that might suffer minor, catastrophic, whatever loss in this city. It could lead to real problems if we just always take a cookie-cutter approach to having to interpret a municipal code. I sent you a lot of stuff. I know you don't have time to read it, but I try to give you a flavor of sort of what the process has been from the standpoint of my client, trying to deal with the carrier, trying to deal with contractors, but mainly trying to deal with the city for the last year and a half. We so much appreciate the opportunity to be heard on this issue because it's vital. It's vital to my client, as I know it is to the city. Thank you for your time.
Is there anyone else in the audience wishing to testify on this matter? See no interest, I now close the public hearing.
Well, and actually, if the Planning Commission doesn't have any additional questions for the Appellant's Counsel, I did want to just make a few statements in response to what they indicated before they close.
Let the record show that the public hearing is still open.
Thank you. So just to respond to a few of the comments that were made, and I'm not going to respond to everything. Again, I think most of the issues have been outlined in both the appellant's paperwork that's been submitted as well as the staff report that's been submitted. But there were a few things that I did just want to talk about. First of all, I didn't indicate that this was not a taking. What I indicated was it is not the same type of a taking as eminent domain, forfeitures, confiscations. Every zoning code, and this is actually set forth in the legal analysis that was provided to the Planning Commission, courts have held that every zoning law to some degrees impairs an owner's rights because you are dictating what they can and can't do with property that they own. Now, there is a difference between a law that exists at the time that you purchase the property, at which point you are purchasing it subject to the laws that already exist, versus a law that comes into play after you own a property. And that's the issue that legal nonconformity looks at. What it looks at is how do we compensate, in essence, the property owner who purchased the property with laws on the books, who started to do something lawfully, but then the city changed the laws. Okay? And that's not the same position that this property owner, the current property owner, is in. This property owner purchased the property with the laws already on the books. The fact that her title company did not disclose something to her, the fact that the prior owner did not disclose something to her or to the LLC, does not put an obligation on the city to go notify a new property owner about a law that's been in existence since 1981. That law is public knowledge. It went through a normal process to get adopted, where notification was given at the time, it was duly adopted. The Planning Commission is required to understand that laws that are currently enacted, we go with the understanding that they were duly enacted, and there's no allegation that this law was not. So at the time that the law was adopted, notification was given. The city is not under an obligation to re-notify every subsequent owner who purchases this property of a law that is already on the books. So while I understand what counsel is arguing, that the LLC may have gotten, if you will, a raw deal by not knowing about this, it's not the city's obligation to re-notify the LLC. Mr. Weiser talked about the taxes, and I believe Mr. Greenberg might have as well, but Mr. Weiser talked about the taxes, that the city has collected taxes from the appellant, from the current property owner, as well as obviously from the prior property owners. And this was set out in the staff report and in the legal analysis. The taxes that were collected were two kinds: transient occupancy taxes, business license taxes. Transient occupancy taxes are not paid by the property owner or the business operator. Transient occupancy taxes are paid by the occupant. Every time you go to a hotel, there's a surcharge. You pay that tax. That tax is held in trust by the business operator and then turned over to the city. So there's no detriment to a business operator for paying transient occupancy taxes that never came out of the business operator's pocket. Now, business license taxes, of course, did come out of the appellant's pocket as well as the prior business operators. But that in and of itself means that you paid your taxes for the right to conduct business. And guess what? You benefited from that because you conducted business. But that doesn't make the fact that the city issued a business license, which it is required to do because the taxes were paid. Business license is really, in essence, a receipt. You've paid your taxes, here's your license. The city can't deny it if the taxes have been paid. But the fact that the taxes were paid doesn't mean that everything is now legal and okay. Al Capone was prosecuted for not paying his income taxes. He did income taxes off bootlegging. Okay? The collection of taxes is a revenue-raising function. That's it. It's not about approving something from a zoning standpoint. It's not about saying what you're doing is legal. It's not about saying, hey, you're going to be able to continue to do this for the next 50 years. It's about, thank you, you have paid the taxes, and you get to enjoy the benefit of operating a business. And it is true that the appellant had a business license from the time that the appellant took over the business in roughly January of 2015 to the end of 2017. So at the time that the fire had occurred, there was a current business license. That business license expires at the end of the year. So the business license was still in operation all the way through the end of 2017. Obviously was not renewed for 2018, but no business has been going on at the location, so therefore a business license wasn't required. But the fact that the taxes were paid doesn't give someone the ability to continue operating. There's no expectation. Now, the business operator may have thought there was an expectation, but legally, there's no expectation that's given that just because you have been granted a business license for having paid taxes that you owe because you are operating a business in the city, that you will continue to be able to do that. Lastly, and I'd just like to read a quote from a case, and it is in the staff report, but I think it is important just because of one of the issues, again, that Mr. Weiser brought up, which is the issue about the taking. And as I've indicated, the courts have held that, you know, almost any zoning regulation is a form of a taking. But in the Gage versus City of Los Angeles, or the City of Los Angeles versus Gage case, which is cited and quoted in the legal authorities that was provided as part of Attachment 7A to the staff report, this is how the court reasoned that the particular law that they were dealing with was a constitutional taking. And so, in response to both Mr. Weiser and Mr. Ducey, I'm not requesting that the Planning Commission look at this as a cookie cutter and just apply it and be done with it. To the contrary, and I've said this already, and it's in the staff report and in the presentation, the Planning Commission is required to look at this type of a case. The 20 years is a prima facie 20-year abatement period. It's your obligation to weigh the facts of this particular case and make a determination about whether those factors have been met and whether or not the 20 years, and again in this case the 38 years, is reasonable and appropriate. So we're not asking for a cookie cutter. To the contrary, we're saying weigh the factors in this particular case, but even when you do, we believe that the 20 and the 38 years that have been granted is sufficient. But I do want to just draw this particular quote from the Gage case. The court, in holding that the City of Los Angeles non-conforming law, which, by the way, only provided 5 years instead of the 20 or the 38 that's been granted here, the court reasoned that the distinction between an ordinance restricting future uses and one requiring the termination of present uses within a reasonable time is merely one of degree. And constitutionality depends on the relative importance to be given to the public gain and to the private loss. The elimination of existing uses within a reasonable time does not amount to a taking of property, nor does it necessarily restrict the use of property so that it cannot be used for any purpose. The use of an amortization scheme provides an equitable means of reconciliation of the conflicting interests in satisfaction of due process requirements. As a method of eliminating existing nonconforming uses, it allows the owner of the nonconforming use, by affording an opportunity to make new plans, at least partially, to offset any loss he might suffer. The loss he suffers, if any, is spread out over a period of years, and he enjoys a monopolistic position by virtue of the zoning ordinance as long as he remains. If the amortization period is reasonable, the loss to the owner may be small when compared with the benefit to the public. Nonconforming uses will eventually be eliminated. A legislative body may well conclude that the beneficial effect on the community of the eventual elimination of all nonconforming uses by a reasonable amortization plan more than offsets individual losses. And that's what we're asking you to do, is make that very same determination. In this particular case, is the amount of time that's been granted reasonable and compared to what the losses, and again, the person that we're looking at is really the person who lost it at the time that the law forced the property to become non-conforming. Because the current property owner purchased it with these laws and the time periods and everything already on the books. And it's inherent on a property owner or a prospective property owner to do their due diligence. It's not inherent on the city to go out and re-advise every single property owner about laws that are on the books or other defects that in this case are really patent defects. They were there. They were there for the property owner to find or the prospective buyer to find. The last thing that I just want to say is, and I completely understand Mr. Ducey's position, and I don't necessarily disagree with factually some of the stuff that Mr. Ducey is indicating with respect to the amount of time, obviously, from the point when an appeal occurred to the time when we're having the hearing. And while that may have had a impact upon the current property owner, I want to be clear about a couple of things. The plans for the rehab after the fire were submitted in January of 2018. The fire happened in February of 2017. So as much diligence as counsel asserts that the property owner did during that time, and there may have been factors that were out of the property owner's control, the 11-month gap had nothing to do with the city. The city doesn't control when an applicant submits plans. So the plans were submitted in January of 2018, and the review, and as a matter of fact, they were submitted on January 2nd of 2018. Engineering approved the plans almost immediately, within a few days. The planning division approved the plans on January 30th, approximately 28 days after the plans were submitted. And the building department approved them on February 19th. That's a very quick turnaround. So while I understand that the current property owner has not been able to do what the current property owner wants to do, and that the current property owner may have submitted an investment in order to try and obtain new permits and approvals, until such time as the order of abatement was issued, the city is required to process the applications, and process it did. And it processed it timely and in actually a relatively expedient fashion when you think that it got through the entire approval process in less than 2 months, in about 45 days or so, which is a relatively quick turnaround for a municipal government, for a planning division and a building and safety department to get through that process. So that delay, but at the end of the day, that delay does not impact 38 years that had already gone by. The question is about that, and it's about the factors that were put up, and the authority stating that the city's law is legitimate, it is constitutional, it is valid, is what's been put in the staff report. Case law has upheld a city's right to terminate a nonconforming use by providing an amortization period so long as that period of time is reasonable. And the city itself has enacted a code that sets out factors to assist the Planning Commission in making the determination about whether or not that period of time was reasonable. And those are the factors we went through. Thank you.
Absolutely.
I'd like to respond, and also Mr. Weiser.
Would you keep this to 5 minutes?
Not a problem. I'll do it less than that. Addressing what Mr. Eckert has discussed. When we're talking about taxes, that's not the issue. What the city had, if this was an apartment building, a rental unit, and it was non-conforming, bootleg, or something of that nature, the city would tell the owner, you cannot collect rent, you cannot have people occupying this. That's not what happened here. There was an obligation of the city to let the owner know there was a problem. It's not a question of the ordinance in 1981 or 2001. They accepted the business license money, and that's what is important. That's essentially a waiver, and that's what we find here. The city had an obligation. They did not perform on that. And as Mr. Ducey said, there was a situation with the insurance company. This property, to repair it, is millions of dollars. There was a dispute with the insurance company. That took time. Money has to come from someplace, particularly when there's no income coming in. Now, Mr. Weiser will address some of the other issues.
I'll be very brief.
Okay.
And I appreciate what Mr. Eckert indicated about the Gage case, City of LA versus Gage case. But if I'm not mistaken, that was a state appellate court case, not a case in the Ninth Circuit or in federal courts. We're in federal court, and I believe that we're compelled by U.S. Supreme Court authority under the Supremacy Clause of the U.S. Constitution. There is a case. It is a lot more complex, with all due respect to Mr. Eckert, than the way it is being portrayed to the Commission. There is a split of authority in the federal circuit courts. There's a case called Lucas versus State of South Carolina, in which the Supreme Court seemed to indicate, as Mr. Eckert is arguing, that there are background principles that an owner takes, and that those background principles somehow limit the takings clause, and that would somehow limit a takings claim. But subsequent to the Lucas case, there was a case decided by the U.S. Supreme Court called Palo Ozo versus State of Rhode Island. And in that case, it seems to suggest that the Lucas case is not the final word on it, and there is a split of federal circuit authority. There are circuit courts that hold that, in fact, those background principles do not limit the issue of the takings clause. And so that an owner such as this, who has come in, invested, and got a business license, it's not an issue of taxes, but the city permitted the use at that property by issuing a business license, permitted that the owner could collect transient occupancy tax from the public, permitted the owner during that period of time to invest into the property. Those are extraordinary circumstances which limit the city's ability to just simply say and terminate this use. So I would submit that there is a viable takings argument, and I would also submit, and with all due respect to the Commission, ultimately, the issue of the reasonableness of the amortization period, and I do take issue with that issue also, because that's going to go into the issue under the Fifth Amendment of just compensation, whether in fact the 20-year period or 38-year period under the facts of this case is an equivalent of just compensation under the Fifth Amendment. That's going to be decided by a jury. And no matter what the city argues, that is a de novo standard. However, I think it would be very, very foolish for the Commission to give a hand to my client by terminating the use and giving an upper hand to say, okay, we do have an actual taking here. That's why I think what Mr. Greenberg and Mr. Ducey have suggested, which I think Mr. Eckert has not addressed, continue this matter, give my client a chance to try to mitigate and make a win-win situation for everybody, get a CUP, and then we don't have to argue about all these abstruse and esoteric legal issues. Give her the ability to come back and operate under a CUP, and then the whole issue is taken care of. Thank you.
Mr. Eckert, anything?
I do have a question, actually, so closing. Is there anyone in the audience wishing to testify on this matter? Seeing no interest, now close public hearing, public testimony. I do have a question for counsel representing Dalewood Holdings. At any time, and I know that neither of you here were representing Dalewood Holdings at the time of the purchase, but can anybody confirm whether or not anybody with Dalewood Holdings entered into any communications with the city to verify the status of the land use outside of the use of the title company? I just want to make sure that they did do their due diligence and it wasn't a city error.
Thank you, Mr. Chairperson. I'm not aware of any such communications.
Right. Thank you very much. So, Mr. Eckert. So, I know it's not something that we're here to decide, but so in 1981, it's quite possible that when the zoning use changed, that the prior owner was notified of change. Right. The city, Dalewood Holdings never entered into communications with the city to verify the status of the land use when they invested in the property and established their investment expectations, right? So I don't see how the city was at all at fault with the land use, right? But I do have a question. The city statute that gave the property a 20-year non-conforming use does it require the city to end the use at 20 years, or gives the authority to the city to end the use anytime after that 20 years?
The statute requires, the statute is not so much an order upon the city. It is a law that says uses must terminate at that point in time. That's what the law says. And then there's a procedure that the city goes through in order to officially invoke that termination. And that's basically the process that you're going through now, which is the order of abatement was issued in March of 2018. Over the course of the next couple of months, the appeals were perfected, and we are here for the appeal hearing. So there is still a trigger that needs to be pulled, if you will, which was the order of abatement that was issued. It's not... But the obligation is, as laws are, the obligation is an obligation on the property owner to terminate it within that 20-year period of time. But like other things, people don't always do what they're supposed to do, and then it is inherent on the city to move forward and do what it does, which is what happened in this case.
Okay, and then last question. So I believe I read in the staff report that upholding the order of abatement wouldn't stop them from applying for a CUP, right? Like they could apply for a CUP to bring their site up to standards. They have indicated that they are in talks with investors to bring the facility up to the 100 rooms, but upholding the order of abatement prevent the Dalewood Holdings from applying for a CUP?
No, not at all. The current property owner and prior property owners, in essence, part of the reason for providing the amortization period aside from recouping loss is to allow you to come into compliance with current laws as well and continue the use where possible. So although in some cases when a city changes a zoning code, that may actually result in a use being prohibited. So, for example, had the city pass an ordinance that not only said there's a 20-year abatement period, but we're no longer going to allow hotels in this particular zone at all, then that's where we're really talking about, you know, what else can I do with this property? But in this case, that didn't happen. The law does allow for the motel use to continue at that property with a CUP. In denying the appeal here, they would still have every right to still submit for a CUP. They have that right now. They will have that right until such time as the laws change again. But at this point in time, you know, yes, they have the right to apply. If the Planning Commission upholds the order or denies the appeal, they would still have that right, and it would have no impact on their ability to submit for the CUP. I can't say whether there would be other impacts. I know that council has requested a continuance. I can't say whether there is some perceived benefit on their end of still having this as a open question pending the submission of the CUP application versus them submitting the CUP application after a decision has already been made. And I would leave that up to council to, you know, discuss that benefit if they think that there is one, or some viable reason why the council should do that, or the Planning Commission should do that. But to respond to your direct question, no, they would not prevent them in any way, shape, or form from submitting an application for a conditional use permit to operate. And again, they're not currently operating, so.
Chairman Sons, I have a question for Attorney, is it Weiser? No, in front of you, the gentleman in front of you, sorry.
Oh, Mr. Greenberg.
Yeah, Mr. Greenberg, Attorney Greenberg. I have a question for you. So, to that end, what do you and your client want to, with this 4 or 5 month extension? What are you trying to accomplish? Just to be clear, what is it that this time frame is going to, what's that going to change?
It'll help in several ways, and I appreciate the question and the opportunity. As I stated today, and I discussed with Mr. Eckert several times, one, we have spoken many times with the contractor within the last 2 to 3 months as to what can be done. Two, we have spoken to the architect. So it can be done. We have also, my clients have spoken with Holiday Inn. They are willing to come in on this property as the franchisor. If there is a denial here, that could impact upon Holiday Inn. And I think Holiday Inn being here not only would help my client, but frankly would help the city. It's a national known chain. So that's why we would like it continued. That will give us the opportunity to put it together. And as Mr. Ducey had said, there a lot of the problems, and we're not blaming the city, there were problems with the insurance company. Since my client did not have money coming in over that period of time because the property was literally destroyed, money was needed. It took time to put things together. And as Mr. Ducey has said, over $1.9 million has already gone into the property since the fire. So all we're asking for is an additional 3 to 4 months that is not going to harm the city in any way, but it will help my client.
Thank you.
Thank you.
So, Commissioners, any further discussion?
Mr. Chairman, this is a unusual matter. It's very complex. I've never had to ask for a 5-minute sort of recess for staff to discuss this further, but I think if there were ever a chance or opportunity, this would be it. So, may we have 5 minutes to discuss this? And
Actually, I think this is a perfect opportunity for a recess, so I make a motion to recess for 5 minutes.
Thank you.
Second.
All those in favor?
Aye.
Recess. So make a motion to extend the current recess an additional 10 minutes.
I second that.
All those in favor?
Aye.
Motion passes.
Mr. Chairman, just a quick update. We're going to have the legal counsels talk outside just for, I don't think it'll take more than a couple minutes, and then we'll be prepared. Thank you.
Thank you.
They're really pushing that.
Tell me about it. I have a story of my own about that.
Yes, I was asked to street the connecting family. Sorry.
Does he know the?
We have contact with them, or, contact with the family. On the first marriage. Already met 3 of them. Others.
Last name between.
Have in contact. Leave Noah.
We've connected like test. The younger ones are all.
Are like, oh. It's okay. Nice. Marco started this. This was my. For next year. So we'll see how that goes.
Birthday. Got my results. Surprised. Well, not surprised with the breakdown of my background and heritage,
Right.
but I got an aunt. Like it was exact. Like it told cousins were cousins.
Second, third, fourth.
So my second cousins, right? Second cousin, that's really, it was like spot on. A lot of my mom's family was on. Out to me was the fact that I had aunts. It's somebody top of the hierarchy. I had an aunt, and my mom, like, weird because my parents are only children.
They're only child.
My parents are only children, so hugged me. Assumed that my grandfather had like and so I asked my dad to so I told my mom, so I bought her the test. Test that dad isn't real. Some of them are family crew from New York.
I heard another story.
Worker. Found out that her dad was in her.
How did your mom feel about that?
She was mad at her mom because my grandfather passed away. She never, after my grandfather died.
You've never known.
So the commission is now returning from recess.
Thank you, Commissioners, and thank you for that recess. During that recess, I did have an opportunity to speak with staff as well as with the appellant's counsel. And based on our discussions and the appellant's request for the continuance of 4 months, staff is prepared to join in that request that the Planning Commission close this hearing as it has, to continue the hearing to a date certain in about 4 months, to grant the appellants an opportunity to submit for that CUP application.
Is there a date in which they must submit?
So I'm looking at the calendar, Commission. I'm sorry. So 4 months from now, we're looking at December, probably the second meeting in December, December 11th. I'm sorry. Yeah. Oh, I'm sorry. I'm sorry. I'm sorry. We're recommending that January, which falls on the second meeting of the first meeting in January, which is January 8th, Wednesday, January 8th.
So if there's no further discussion, I'd make a motion to table. I make a motion to table Resolution 1916 and bring it back at a future meeting of January 8th, 2020.
Yes.
That means that the public hearing is closed and it would only be coming back for further deliberations. Is that correct?
Correct.
Okay.
So I've made the motion. Any second?
I second that.
A second. All those in favor?
Aye.
Aye.
Aye. Motion passes 3-0.
Thank you.
Still gotta finish. It's still going.
So at this time, we're going to move to reports of officers.
Yes, thank you, commissioners. As you may know, if you've been notified, but Chairman Kevin Rooney officially resigned from the Planning Commission. As we thanked Mario for his service on the Planning Commission, would also like to extend thank you to Commissioner Rooney for all his years of service in assisting the city with the Planning Commission. So thank you.
Thank you. I think if it's at all possible, if we can just draft a letter thanking him and drop it in the mail, just thanking, I don't know if that's at all a possibility.
Yes, I can.
Just draft thank you and I guess to show our appreciation.
Absolutely.
Thank you. Any additional reports of officers?
No, not at this time.
Commission, any communications?
There's one more. Hold on, let me just interject. I just wanted to remind the commission we do have another scheduled planning commission meeting at the end of the month on the 28th. We have an item scheduled, so you'll be notified of that item for that meeting date.
Thank you. I do have a question, and this is probably something that's probably going to be ongoing. But as far as the city's current practice or their enforcement actions, like I guess if had this fire, like for this particular case, if this fire had not happened, we would have never realized that they had been 18 years past, 18 years out of their time frame. I just want to know how often does the city comb through, or is that something that we even have the staff to do, to comb through different zones to ensure that we are taking the appropriate action at the appropriate time,
Good question, Commissioner Sands. Absolutely. I cannot speak for what happened. I was not here at the time that occurred, but I can tell you in my experience in working with planning staff, when properties do go through the due diligence before purchasing a property, they do process a zoning conformance letter, and at that time, that's when staff will determine and analyze whether the use is non-conforming, and also provide them with future past approvals on that property, in addition to copies of resolutions, staff reports, and also sections of the municipal code, whether that be development standards, the non-conforming section, that is provided to them at that time, and that occurs again at the time that prior to the purchase of the property.
And so I guess in 1981, there was no electronic means of publishing this information that this property was no longer the appropriate land use. But now, do we, now that we're in the technological world, do we publish, when we change zones, do we publish a list so that title companies can pull that electronically, or is that still something that's like we have
Good
to
question. The only notification that does occur is when we do a citywide notice when there's a code amendment to be done, whether that be, development standards, setbacks, but they're not recorded.
Yeah, those documents aren't recorded at the county, so typical search by a title company
would have never picked
wouldn't have. But to further answer your question, Mr. Chairman, staff is, everywhere we go as professionals, there's always concern about the amount of staff resources. Obviously, when we become alert to something like this, we're going to make an effort. But I got to tell you, it's really difficult because you're trying to keep up with just the new stuff, as we say, and the ongoing things and requirements. So it's very difficult. It is a challenge, but it's something that we'll definitely look at.
And I thank the entire staff, because I think you guys do an excellent job in everything that you do to help us. So it's not, I'm not knocking anybody. I just like future endeavors, I guess, for as we're moving more into the technological world.
One thing I'd like to add in addition to that is just speaking with staff is, since I've been here and staff has been here, when we do get business licenses, we do let the prospective business of their non-conforming or conforming status.
Oh, okay.
So that is part of the review process when they submit a business license.
Thank you very much. So if there's no further comments by the commission, any motion for adjournment?
I move to adjourn.
I second that.
All those in favor?
Aye.
Motion passes 3-0. We are now adjourned.